Please keep your microphones muted and your cameras off throughout this webinar. If you don't wish to be recorded, then you cannot participate in the discussion part, because we will also record the questions and comments after the presentations. Please use the chat for any questions or comments you may have, and we will share all the slides after the webinar, including links to the materials. And the recording will also be made available afterwards. The program today, we will be presenting the findings of our project on remedies in the Nordic and Baltic Sea region. My colleague Saara Haapasaari will present the findings from Finland, and our colleague from the King Institute, Tina Davis, will present the findings from Norway. The presenters will alternate during the presentation. And then we will have finally a commentary from Christopher Ritzelius from ETI Sweden. As some very brief introduction to Heuni, we have the next slide, yes. We're an independent research and development institute working across Europe, but situated in Helsinki, Finland. And we have been working on labor exploitation and forced labor for over the last 15 years. We cooperate very closely with all parties relating to this topic, businesses, public procurement, all the labor market parties, authorities, and NGOs. But we also work specifically with companies to strengthen their capacity to work on the prevention of labor exploitation in local and regional supply chains. Before I give the floor to the speakers, I want to thank all our project partners, that is the Coretta and Martin Luther King Institute in Norway and the Ethical Trading Initiative in Sweden, as well as the project donors, that is the CBSS, the Council of the Baltic Sea States Project Support Facility, and the Swedish Gender Equality Agency. And next, I would like to give the floor to Saara Haapasaari. Saara, you have the floor.
Thank you so much, Natalia. I'm Saara Haapasaari, and I work as a sustainability specialist at Heuni. And I will give you a brief background of the project and the topic. So Heuni has led for the past year a project where we have mapped the different grievance mechanisms in Finland, Norway, and Sweden that can be used in cases of labor exploitation that occurs in these countries. We have assessed how these different mechanisms function in practice and whether they provide any remedy for the exploited workers. We have identified several barriers and gaps in migrant workers' access to remedy compared to the UN Guiding Principles. And in our report, which is published today, we give several recommendations to improve migrant workers' access to remedy through these different mechanisms. And in addition to the more thorough country mappings, we have gathered good examples of remediation and grievance mechanisms from the larger Baltic Sea region. As Natalia mentioned, the project was conducted by Heuni together with the Coretta and Martin Luther King Institute from Norway, as well as ETI Sweden. We have used a variety of data in the project, including interviews with several experts. But one limitation is that we did not interview migrant workers themselves. When we talk about labor exploitation, we talk about a set of abusive conducts where workers are subjected to poor working terms and have little or no possibilities to change their situation. Exploitation can be seen as a continuum of situations and acts which range from less severe to more severe forms of exploitation. Depending on the severity of these situations, the cases can be defined as different types of labor violations, forms of exploitation, or human trafficking or related offenses. Human trafficking for forced labor is criminalized in all of the covered countries, and in addition, there are some different national criminal provisions that tackle the exploitation that does not meet the threshold of human trafficking. For example, in Norway, wage theft is criminalized. Sweden has a provision on human exploitation, and Finland has a provision on extortionate work discrimination. We will say more about these in the country findings. The risk sectors for labor exploitation in the focus countries include labor-intensive sectors with long and complex supply chains, such as agriculture, fishing, construction, cleaning, service industries, and transportation. And very often, labor exploitation looks like regular work, but it can be identified through certain key indicators. Heoni has researched the topic for a long time, so please visit our website for more materials on the topic if you are interested. And labor exploitation is a structural problem, which is typically hidden within legitimate business structures, such as subcontracting chains, letterbox companies, posted worker schemes, and bogus self-employment. It is profitable for the perpetrators, and there is low risk of getting caught since there is limited regulatory oversight. Migrant workers are especially vulnerable to exploitation since they may not know the local language or speak English. They may not be aware of their rights in the labor market and where and how to seek for help. And they may be afraid of retaliation from their employer or fear deportation if they report the exploitation. And they might be indebted for possible recruitment fees and other costs related to securing the job. And these same characteristics that make migrant workers vulnerable to exploitation can also limit their access to remedy through different grievance mechanisms. We use the UN Guiding Principles on Business and Human Rights as the starting point for our mapping. The UNGPs consist of the state duty to protect human rights, the corporate responsibility to respect human rights, and both state and businesses have a shared responsibility over remediation in business-related abuse. So, as part of the state duty to protect against business-related human rights abuse, states must take appropriate steps to ensure through judicial, administrative, legislative, or other appropriate means that when such abuses occur within their territory and/or jurisdictions, those affected have access to effective remedy. And regarding businesses, where they identify that they have caused or contributed to adverse impacts, they should provide for or cooperate in their remediation through legitimate processes. The UN Guiding Principles apply to all of our focus countries, and the countries have, for example, created national action plans on their implementation. According to the UN Guiding Principles, there are different types of grievance mechanisms that complement each other. The state-based judicial and non-judicial mechanisms form the foundation for the wider remedy system. And businesses' operational level grievance mechanisms can provide early stage recourse and resolution, hopefully before the abuse escalates to more serious violations, and especially if the mechanisms meet certain effectiveness criteria stated in the UN Guiding Principles. In the Nordic countries, social partners have typically had a large role in regulating the labor market, and trade union membership has been a traditional way of providing protection in labor disputes. And lastly, NGOs and civil society organizations have a central role in supporting different rights holders in these different judicial and non-judicial processes. Previous research and also our project shows quite clearly that in theory, there are several grievance mechanisms existing on paper, but in practice, there are different barriers in migrant workers' access to remedy through these different mechanisms. Here you can see some of the different grievance mechanisms we have addressed in our report in the focus countries. First, the judicial mechanisms include the criminal justice process for human trafficking and the other national criminal provisions related to labor exploitation, as well as civil litigation and labor courts. Other state-based mechanisms include, for example, different administrative processes to get compensation, such as wage guarantee in cases where employers are insolvent. And then there are special ombud offices Chancellor of Justice in certain countries, as well as the national contact points of the OECD guidelines on responsible business conduct. And in addition, there are trade unions and NGOs, as well as corporate grievance mechanisms. And when we talk about access to remedy, we talk about a large amount of different institutions, actors, and mechanisms. In this picture, we wanted to show the number of different actors and grievance mechanisms that can be relevant when accessing remedy for labor exploitation. And in addition to these institutions and organizations, there are a number of different laws and policies that together form a larger remedy ecosystem. The affected stakeholder or the exploited worker should be at the core of the different grievance and remediation processes. And in this project, we wanted to bring together experts from the business and human rights field, as well as the anti-trafficking and anti-exploitation actors, which in many Nordic countries is also defined as work-related crime. And one of our goals is to increase awareness among these both audiences about the different ways to access remedy in the Nordic and Baltic Sea region context. Now we can continue to the findings from our focus countries, and I'll start with Finland. We won't be able to go through all the findings from our report, but rather just highlight the most relevant aspects of these different mechanisms. And the report we have published today will have much more detailed information about these different mechanisms and ways to access remedy. In Finland, one of the main avenues for victims of labor exploitation to seek remedy is through the criminal justice process. Finland has the most convictions for human trafficking for forced labor compared to the other Nordic countries. Labor exploitation has also received a considerable amount of attention over the past 2 decades in Finland, which has led to several changes in policies and practices. Finland also has these parallel provisions in the criminal code that can be used in cases that do not meet the trafficking threshold, such as extortionate work discrimination, which has also produced several convictions over the years. And despite the criminal justice process working a bit better compared to the other Nordic countries, the processes are still way too long. They can last for several years. And even with conviction, it might be that the victim doesn't necessarily receive compensation. For example, if the perpetrator's assets have not been confiscated in the process. One good practice in the Finnish remedy ecosystem is the Labour Inspectorate, which has a specific mandate to monitor migrant workers' working conditions and salaries. The Labour Inspectorate cannot order remediation directly to the workers, but they have been central in identifying exploitation at workplace inspections, which has facilitated the start of criminal processes. And the inspectors have, for example, special guidelines on how to act in cases where they suspect exploitation or trafficking, and they interact with the workers by asking questions and sharing information of workers' rights and support organizations. Another interesting state-based actor in Finland is the Chancellor of Justice, which oversees that Finnish authorities comply with the law and fulfill their duties. In 2021, the Deputy Chancellor of Justice initiated a review of Finnish police after media published news about shortcomings in human trafficking investigations. The review and the recommendations by the Chancellor of Justice led to structural changes and improvements in police investigations, and it also led to reopening of some investigations that the police had ended earlier. The Chancellor of Justice cannot order direct remediation for victim of labor exploitation, but it can affect the structures and thus indirectly improve the possibilities to access remedy in the future. Civil litigation was not seen as a very effective mechanism by our interviews in Finland, especially because of the risk of high costs if the case is lost and if a person does not have trade union with legal aid backing them in the process. But indeed, another main avenue to seek remedy for labor exploitation in Finland is through trade unions. For union members, the support is rather extensive and may even cover legal aid to take disputes to courts. But since many migrant workers are not members of the union, the Finnish trade unions that operate in these risk sectors have different practices regarding the level of assistance they give to these non-members. There are great examples of committed individual trade union officers who have assisted non-members through contacting their employers or larger buyers in the supply chain. But typically, the unions assess case by case whether and how they can help, and it is not necessarily very transparent who gets help and who doesn't. But in practice, most migrant workers in Finland get at least some advice from the trade unions on how to proceed with their case. NGOs in Finland, and especially Victim Support Finland, which has a special support service for victims of trafficking, have had a very central role in facilitating exploited workers' access to remedy through different grievance mechanisms for several years now. The unions, NGOs, and the authorities in Finland cooperate also quite a lot. They, for example, share information with each other, refer cases to each other, or give tip-offs to authorities and support each other's clients. This cooperation could be described as an unofficial multi-stakeholder initiative, since they have established connections and partnerships with each other, which has facilitated exploited workers' access to remedy. And lastly, businesses in Finland could still strengthen their role in providing remedy in cases of labor exploitation. The most typical form of remedy provided by Finnish companies for labor exploitation in our study was compensation for unpaid wages and other costs. And in addition, we found examples of repayment of recruitment fees, as well as offering jobs to exploited workers. Previous research, as well as companies' public sustainability reports, show that companies do not disclose much information about cases of remediation. We do know, however, that there are regularly cases, for example, in the construction sector, where trade unions have been central in using leverage to pressure main contractors to require remediation from their suppliers, or provide for remediation themselves, but the construction companies haven't really disclosed information about these cases themselves. Now I'm happy to give the floor to Tina.
Good morning, everyone. Thank you so much, Natalia and Sarah, and thank you so much to all of you who are here with us this morning for the launch. Next slide, please. Thank you. My name is Tina Davis, and I work as a researcher and special advisor with the Coretta and Martin Luther King Institute for Peace, King Institute. The Institute was established in 2019. It works with research and practical application in Norway and internationally across 4 thematic areas: human rights, including labor exploitation, conflict, refugees, asylum seekers and migrants, and youth. I will now share a snapshot from the Norwegian mapping. Next slide, please. As Sarah mentioned earlier, there is a continuum of exploitation also in Norway, from irregular contracts, extreme work hours, and exaggerated recruitment fees and costs, to wage theft, abuse, and in some instances, forced labor. When it comes to the state-based judicial grievance mechanisms and how they function, I will start by mentioning the criminal provisions. There are few convictions of human trafficking in Norway, and the majority of the convictions are related to sexual exploitation. Possible victims of human trafficking do get a lot more support in remediation processes in principle than persons who do not meet the human trafficking threshold in cases of labor exploitation. Potential victims of trafficking do, however, need to report their case and apply for a 6-month reflection period to trigger their rights and access support with housing, health funding, and so forth in the remediation process. Many are afraid of reporting their cases and due to reprisals, and do not wish to apply for a reflection period. Also, potential victims have to have a legal residency permit to be able to receive support. Norway does not have a national referral mechanisms. There are few police investigations, and a lot of cases are dropped. Experts have identified a grey area of exploitation that does not meet the high threshold of human trafficking or for forced labour, and that is not captured by a legal provision. This has implications for many migrant workers who nevertheless experience severe exploitation. A new law against wage theft was introduced in 2022 to cover some of this grey area. Norway is the first country in Europe to introduce a wage theft law. Findings point to wage theft being a common form of exploitation in Norway, and so far there have only been one conviction under the new law, and as many as 90% of the cases are dropped by police without investigations. One of the reasons is a lack of resources, which then prevents this law from being an effective pathway to remediation. There are discussions about the need for another law that will capture severe exploitation, as wage theft does not fully cover the mentioned grey area. Finland, Sweden, and Denmark already have variations of such a law in place. Many cases of wage theft go through a civil litigation process, which is the most common avenue for financial compensation. However, this process is complex and there are multiple barriers. An employee has to file a case personally. There is no access to free legal aid in wage theft cases. The process is complicated and requires good knowledge about the system. Language is often a barrier, and it can take up to 2 years. It is also costly. Many violated workers would have to leave the country due to lack of funding or visa expiring much before the 2 years time frame, and will therefore not be able to see a remediation case through till the end. The Labour Inspectorate, which represents a state-based non-judicial grievance mechanism, is an important mechanism for migrant workers. However, the Inspectorate primarily follows up businesses when violations are detected by giving them corrective orders or fines, or in more serious cases, reporting them to the police. They do not primarily follow up the needs of the workers, which is a surprise to many migrants who report incidents to them. Although that said, the Labour Inspectorate has since 2022 been able to impose orders on employers to pay outstanding wages in certain cases in sectors where there is a minimum wage, and they can impose order to pay overtime in all sectors. Trade unions provide support for all members in remediation cases. The support for non-members, which concerns a large part of migrant workers who are in Norway temporarily on seasonal visas or otherwise, is more limited. LO, the Norwegian Confederation of Trade Unions, do give limited free legal aid to some affected workers, and trade unions either refer workers to them if they have a clear case, or they sometimes contact buyers or businesses in the supply chain and engage in dialogue directly to try and get access to remedy this way, or they refer them to NGOs. The NGOs are key facilitators and remediation processes for migrant workers in Norway, and in large parts they fulfill a similar role as trade unions for the non-members. However, it is coincidental who find the NGOs and therefore can access their services. One reason is that there is not good enough access to information for migrant workers about their rights, how the system works, and where they can seek support. The NGOs are stretched for resources and have to make choices about what cases they can take on. This means that there will be many violated workers who do not get support in access to remedy. Norway introduced another law in 2022, the Transparency Act, which is aligned with the UNGPs, and it is a human rights due diligence law for businesses. Larger businesses have to conduct due diligence under the law and publicly report on the process and the findings. Although the law is still new and a recalibration phase has been expected, the current level of transparency when it comes to how companies report on their work with grievance mechanisms and remediation cases is quite limited. This makes it difficult for stakeholders to understand how businesses work with remediation and the extent to which they provide access to effective remedy. So saying that doesn't mean that they don't do this, but when it's not reported, it's hard for stakeholders to scrutinize the work. I will stop here. Thank you so much. Sarah, please continue with the Swedish one.
Thank you so much, Tina. And to the last country findings regarding Sweden. When comparing the Nordic countries and court cases on labor exploitation, Sweden has the least amount of convictions. In 2018, Sweden introduced a new criminal provision, human exploitation, which objective was to tackle better the cases of exploitation that do not meet the criteria of human trafficking. However, a recent research by Märta Johansson shows that between 2018 and 2023, out of the 385 police reports on human exploitation related to labor exploitation, only 7 led to prosecutions, of which only 2 led to convictions. And there is no convictions for forced labor since 2012 from Sweden. The criminal justice process in Sweden does not thus provide sufficient remediation or protection to victims of labor exploitation. In recent years, Sweden has also established centers against work-related crime in different regions where multiple authorities are located together. The aim of the multi-authority cooperation is to conduct joint inspections and other activities to combat work-related crime, including labor exploitation. And this has created structures for enhanced collaboration between the different authorities, but there is still, however, some challenges in sharing information between them. And we also see that there is a lack of victim-sensitive perspective, and the rights of the victim are not considered and protected enough in the work-related crime model, since the focus tends to be more on getting the perpetrator caught. There is still room for improving the victim perspective through, for example, the regional coordinators against trafficking and prostitution, as well as through increased cooperation with NGOs. But however, the practices across the country vary regarding these collaboration. A very structural element of the Swedish labor market is the Swedish model, meaning that trade unions and employers' organizations regulate the labor market through collective agreements. Compared to, for example, Finland and Norway, the Labor Inspectorate in Sweden does not have a mandate to inspect wages, since it is the responsibility of the social partners. Trade unions oversee the working conditions and wages of their members, but migrant workers are often not members of unions, which raises the question of who looks after migrant workers' rights. And as a result, there is a risk that migrant workers who are not trade union members are left without any oversight in Sweden. The large traditional unions have established some mechanisms where they aim to support this group of workers, such as the Union Center for Undocumented Migrant Workers, but these organizations are able to assist only a few of the workers since they have limited resources. Another example is a small syndicalist trade union, SAC, which has also made the strategic decision to help newly joined members with past disputes compared to traditional unions who typically require a couple of months membership before granting assistance. They have been quite successful in claiming back unpaid wages, but are also operating with very limited resources. And as is the case in the other focus countries, also in Sweden, the NGOs play a vital role in providing support services to victims of exploitation, as well as facilitating more victim-centered processes with, for example, the police. And Regarding businesses, large Swedish businesses have quite good global human rights due diligence policies and processes, but based on our findings, there has been less attention put to the local supply chains and the exploitation taking place in Sweden. However, there are promising examples of collaboration regarding migrant workers' rights in Sweden, such as ETI Sweden's work regarding the berry industry, as well as IKEA's collaboration with IOM to improve migrant workers' conditions in the berry sector, as well as in IKEA's global supply chains. In addition to these country mappings, we also did an overview on the larger Baltic Sea region and tried to look for good examples of grievance mechanisms and remediation in cases of labor exploitation. The report has several examples, but I'm now lifting a couple ones to give you an overview of the variety of these different examples of accessing different forms of remedy. In the project, it became quite clear that often securing a job is a very important form of remedy for exploited workers. I'll present two examples of offering jobs as a form of remedy. The first is a case example from construction sector in Norway, where several complaints of wage theft and manipulated timesheets were submitted to multi-stakeholder initiative Fair Play BUK's grievance mechanism. After receiving the complaints, Fair Play BUK contacted the Labour Inspectorate and tax authorities, as well as the police, the main contractor, and the construction client. The main contractor started to investigate the issue, met with the workers, and collaborated with Fair Play BUK. Eventually, the main contractor paid the workers unpaid wages, terminated the agreement with their subcontractor, and offered direct employment to the workers. And in the other example from Sweden, Fastighets, which is a union of the cleaning and building maintenance workers, established a regional network against work-related crime in 2023. The objective of the network is to detect unscrupulous employers and gather a network of reliable employers in the cleaning and maintenance sector. The aim of the network is to encourage exploited workers to report the exploitation, help them exit the exploitative employer, and provide fair work for them among the network's employers. And this hopefully helps the workers to secure a job, a residence permit, and hopefully encourages them to file a police report. Then a couple of examples about the role of public buyers in ensuring and facilitating remediation. In Denmark, the city of Copenhagen has since 2018 had an action team or task force against social dumping. The team conducts unannounced and agreed inspections at ongoing projects to ensure that suppliers and subcontractors of the city are following collective agreements. If any violations are found, the task force starts a dialogue with the employer in question. The employer is requested to pay back the wages and the other reimbursements for the workers. And if they do not agree to remediate, the city can issue a fine to the supplier and withhold their payments and eventually terminate the contract. The task force publishes very good statistics and information of their annual activities. And for example, in 2023, the task force was able to claim unpaid wages for over 100 employees, amounting to almost 70,000 euros altogether. Another example of public buyers is Electronics Watch, which is a non-profit organization helping public buyers to cooperate and monitor labor rights in electronics and low-emission vehicle supply chains. Electronic Watch coordinates worker-driven monitoring and facilitates remediation activities in global supply chains, together with their civil society partners in several production countries globally, including Poland. And in Poland, the civil society partner is the Polish Institute for Human Rights and Business. So Electronic Watch aims to capitalize on the leverage of public buyers in order to promote and protect workers' rights in global supply chains. And they have created worker-driven remedy principles with 10 different principles that emphasize the need to put the workers at the core of the remediation processes. Electronic Watch has facilitated successful remediation processes and outcomes with the leverage of their public buyer affiliates. And workers have, for example, received compensation for unpaid wages and costs of regularization, to name a few. We also wanted to showcase a couple of examples of state-based mechanisms. In Estonia and Lithuania, there are labor dispute committees, which are extrajudicial authorities resolving disputes between employees and employers. The aim of these committees is to reconcile, find a compromise, and reach a settlement agreement. The typical disputes relate to unpaid wages and unlawful terminations of job agreements. These dispute committees are free of charge, and the processes are less cumbersome compared to, for example, civil litigation. However, migrant workers typically need someone to assist them in making the application. And there are also similar problems as in the other processes, such as burden of proof and eventual enforcement of the decisions, meaning that unscrupulous employers do not want to pay based on the committee's decisions. In both countries, there are hundreds, even thousands cases handled by the dispute committees annually, also from migrant workers, but there is no official statistics on how much the workers have actually received after or based on the committee's decisions. Another example is from Finland, where in 2022, a new one-year residence permit type was created for people who are suspected to have been exploited by their employer. This permit enables a person to change employers and sectors, and there is no need to initiate a police investigation in order to get the permit. The number of the issued permits has been quite low, 20 in 22 and 34 in 2023. And even though there have been some awareness raising efforts, it might be that the low number is due to, for example, the cost of the application, or it might be that the persons do not want to see themselves as exploited or as victims. And lastly, a couple of examples of different strategies of trade unions from the Baltic Sea region. In Germany, trade unions have established several advisory centers for migrant workers, where they provide advice on German labor law in several languages, and in some cases, they also mediate disputes. But they do not take cases to court. For example, Fair Mobility provides transparent statistics of their work. And for example, last year, over 7,700 people contacted their advisory centers, and another 1,700 contacted their hotline. Most of the cases are dealt with through advice, so there is no information of how many people actually receive remediation in the end. And in Iceland, the union membership rate is very high, around 90%, which means that typically also migrant workers are members of the union. This year, a new legislation was introduced in Iceland, which formalizes the union's role in conducting workplace inspections. The law enables trade unions and authorities to share necessary information with each other, and this is quite a groundbreaking legislation which gives the unions additional powers and responsibilities. While we did the report, the preparations for the new role were not yet started, but this is something that should be followed in other countries as well and see how it goes. Now I'm happy to give the floor back to Tina.
Thank you so much, Sarah. So we've gone through the key country mappings, and our conclusions are as follows. There are several barriers in access to remedy for exploited migrant workers across the three focus countries, Finland, Norway, and Sweden. Trade unions have slightly different practices and strategies on how much assistance they offer non-members. In our findings, we see that some level of advice is often given, or trade unions refer workers to NGOs that can offer some support in remediation processes. NGOs play a key role in facilitating access to remedy, as you've heard. Violated workers are also often referred to them by government agencies and others. NGOs struggle with limited resources and therefore have to prioritize what cases they can take on. It is also very coincidental who gets access to remedy and remediation. There are several barriers with complex and costly civil processes. Police reports are often dropped, and there is a lack of investigations. The evidence threshold is high in criminal cases, and there are overall few prosecutions. Also, the processes often takes a long time. The UN Guiding Principles framework and the national action plans on business and human rights that has been implemented in each country are not necessarily known and followed or practically applied by all involved stakeholders in the remedy ecosystem. We did find a disconnect between the business and human rights communities and the anti-trafficking, anti-labor exploitation communities. In the different countries, businesses' responsibility to respect human rights is becoming more mandatory with, for instance, human rights due diligence laws and the EU Corporate Sustainability Reporting Directive that companies in the respective countries have to report under and follow. And for instance, in Norway, businesses are continuously improving their human rights work through these frameworks like the human rights due diligence law and the law I just mentioned. Current reportings, though, and the samples that we assessed, which were a small data set, does not say much about how the companies work with their grievance mechanisms, about remediation processes or outcomes. And therefore, more transparency is needed to understand the actual standards and level of access to remedy that businesses provide. More attention should be put towards designing grievance mechanisms that are fit for purpose for the company in question, to ensure that they are effective for the affected stakeholders. Each company's operations are different, so a generalized one-size-fits-all approach to grievance mechanisms will most likely not meet required human rights responsibilities, and it becomes more like a legal response than a human rights response. For the remedy ecosystem to work effectively, we have identified that collaboration and relationships between the different stakeholders is key. So having a comprehensive system on paper does not necessarily work if the different stakeholders don't communicate well and build those relationships. So to conclude, there are large room for improvements in access to remedy in the Baltic Sea region for exploited migrant workers. So we will now share recommendations to improve the situation for exploited migrant workers. And we have recommendations to states, businesses, and the other stakeholders. So first, what states need to do to address the barriers in access to remedy includes improving access to free legal aid for victims of labor exploitation, secure, sustainable and long-term funding for NGOs and victim support providers, develop and implement targeted information campaigns for migrant workers, and making information overall more accessible. Establish effective structures and simplified processes to support victims in accessing compensation and remediation. Give reflection periods to potential victims of trafficking with an undocumented status. Refer all potential victims of trafficking to specialized assistance services. Develop and grant resident permits options for victims of labor exploitation, which will ensure better access to remedy. And finally, update the national action plans on business and human rights so they are currently more fit for purpose for the current conditions in the respective countries. And for businesses, to conduct due diligence in national and international supply chains and in recruitment, include the labor exploitation risks. Involve, consult, and meaningfully engage different groups of migrant workers in the design, operations, and assessment of the mechanisms in order to ensure that they are effective, accessible, and fit for purpose. Communicate proactively and make the grievance mechanisms accessible to workers and others. Be transparent in reporting on grievance mechanisms and remedy cases. And depending on the circumstances, consider employing exploited workers directly where that is possible. And engage in multi-stakeholder initiatives for better collaboration and more effective access to remedy. And also use the UNGP effectiveness criteria to continuously improve the work with the company grievance mechanisms and in access to remedy. And to trade unions, develop a trade union membership fit for seasonal workers and temporary migrant workers. Proactively seek more members from the migrant worker cohort. Engage with businesses in the supply chain to resolve cases of labor exploitation and secure remediation more effectively. Provide legal aid for non-members where possible. Explore possibilities to cooperate and engage information with the Labour Inspectorate and NGOs and other stakeholders. To the NGOs, engage with businesses more in the supply chains as another pathway to secure remedy for affected workers, and also familiarize with the UNGP frameworks and the national action plans on business and human rights. And overall, create multi-stakeholder platforms and establish contact points for better collaboration to create a more effective remedy ecosystem. Thank you so much. I will now pass the word over to Christopher from ETI Sweden, who will share his comments. Over to you, Christopher. Thank you.
Thank you, Tina and Sarah, and many thanks for the opportunity to give a commentary. My name is Christopher Atapaturyd-Celius, and I'm Senior Advisor at ETI Sweden, Ethical Trading Initiative Sweden. We are a membership-based organization that promotes ethical trade and human rights in global supply chains. And through training, advisory services, collaborative projects, and advocacy, we support companies in implementing responsible business conduct. And earlier this year in March, we arranged a roundtable meeting within this project that focused on the business aspect in relation to remedy and grievance mechanism. And arranging this event has been our main role in the project, since responsible business conduct is so central in our work. And at this event, we had two guest speakers from the trade union for the undocumented, and also Electronics Watch, the the case that Sarah just mentioned. So both of these guests talked about their work on remedy and grievance mechanisms, as well as we also had a group discussion during this event. And this roundtable meeting emphasized the need for stronger collaboration among companies, governments, and unions and other actors to improve access to remedy and grievance mechanisms for migrant workers. And despite existing Nordic judicial and administrative systems, migrant workers face significant barriers to justice and remedy, including limited knowledge and lengthy legal processes, as we've talked about today. And the participants at our event also highlighted the need for businesses to proactively address human rights risks, especially through contractual obligations, partnerships, and regular audits. Grievance mechanisms were recognized as essential, but often underutilized tools. Effective communication about grievance mechanism and the involvement of workers in designing remedies are crucial for them to be successful. And the discussion also emphasized ethical recruitment challenges, the importance of preventive measures, and the need for shared best practices and more innovative solutions. And participants also agreed on the importance of continuous dialogue and cross-sector collaboration to strengthen migrant workers' protection in the region. And from the interventions that we have in our work, our impression is that Swedish companies do not work proactively with access to remedy and grievance mechanism for migrant workers in Sweden. It's mostly done in a more reactive way when exploitation has been reported. So for companies who have not started working on these topics, it's crucial to get started, not least in relation to the mandatory legislation that Tina just mentioned. And to improve remediation efforts, businesses should establish clear, accessible grievance mechanisms in workers' native language or accessible in native languages for the migrant workers. And they should work with local NGOs and unions to provide support, and also educating workers on their rights, enforcing labor standards through regular audits, and also integrating remediation requirements into supplier contracts that can help upholding fair practices. And victim-centered remediation that includes compensation and anonymous feedback options is essential, as is transparency in reporting outcomes. Thank you.
Thank you so much, Christopher. Thank you, Sarah, and thank you, Tina, for all your input. We will now open up for comments or questions. Please use the chat function for questions or comments. If you take the previous slide, Sarah, I just wanted to mention that we are now today launching the report, which was just presented. It is available on the Heuni website under publications. It's available in English and it's free to download from there. So please feel free to go and have a look. Without further ado, any questions or comments? Please feel free to write in the chat. If there are no questions, pressing questions at the moment, I might ask one just while we wait for people to gather their thoughts. I would like to ask both, perhaps, or all of three of you, Sarah, Tina, and Christopher, that if there was anything that you kind of that somehow surprised you in doing this study or looking at the issue of remedy. Please feel free to answer.
I'm happy to respond. The disconnect between the business and human rights sort of group or community and anti-trafficking and anti-labor exploitation was quite significant, and many had not even heard about the UNGPs that we interviewed or spoke with. So that was one surprise. And another, although maybe not surprise, but more just a point to reflect over, is that although workers are an equal stakeholder in law with rights, the power imbalances are huge in their role in this, in terms of maybe not knowing how processes are going, not getting information if they are accessing some kind of remediation process, or putting forward a grievance. So those are some just key points.
Thank you, Tina. Sara?
I can continue. I was quite surprised about the fact that how many barriers there actually are in access to remedy, and how only a small part of actual victims of labor exploitation receive remediation. So that was quite a surprise, sad surprise to me.
Thank you, Sara. And what about you, Christopher?
Well, maybe not a surprise, but I kind of had the same reflection as Tina, but that was more like my gut feeling from the conversations I've had before the project started. But maybe more an observation that was clarified through this project, that there is so few good examples, at least in Sweden. So that was really difficult to find. Like, for example, it was not so easy to find good examples to invite to our event and the interactions that we had for that. So it's yeah, that was an observation more.
Thank you, Christopher. Very interesting. We have one question in the chat. I'll read it out for you, unless if you perhaps can't see it. Thank you so much. It's from Ella Cobain in the UK. She says, super interesting, thanks. I'd be interested in the differences you found within the migrant worker category, depending on type of status. So are there issues in access to remedy for people who are on tied short-term visas versus EU migrant versus people who have a irregular status? And are there any implications for our recommendations based on these different statuses? Anybody of you feel like answering this?
I'm happy to start. Undocumented migrant workers are the most vulnerable when talking about labor exploitation. And in Norway, there has been a tendency that they may be deported before they are properly assessed for instance, human trafficking cases. Their access to rights and remedy is non-existent. So there is a difference. And then it is also a bit coincidental when you look at the other group that could be EU migrant workers or third country workers. EU workers can stay longer, so and sometimes they may return, so they know the systems and gradually learn more about the system, and therefore they may get in contact with unions and so forth. The ones that are more temporarily, again, are also, I would say, more vulnerable and less likely to be able to access remediation. And I just want to add one thing that I didn't say earlier, but for instance, in the Norwegian National Action Plan on Business and Human Rights, it's not recognized that migrant workers are in risk of exploitation in Norway. So even in policy, there are that kind of weakness. And also many businesses in their reportings under the new laws don't mention that migrant workers are at risk in home country, although we've seen the berry picking cases with human trafficking in the Nordics. So I think the recognition it needs to start with that recognition also. Thanks.
Thank you, Tina. Sara, do you want to continue, or Christopher? We have plenty of other questions as well, so if you don't feel like answering this one, we can continue, but please.
I think we can go to the next question, which also actually talks about, for example, the Employer Sanctions Directive.
Yeah, if I just very quickly say that there's a question by Amy Weatherburn, thank you, Amy, on whether we see that EU legislation can have an influence on the protection of migrant worker rights and their access to remedy. Amy refers to the corporate sustainability and due diligence legislation, but also asks, what about, for instance, the Employer Sanctions Directive and the new changes that seek to protect third country nationals in the, for instance, revised single permit directive, the revised anti-trafficking directive, or national referral mechanisms? So do we see any kind of influences in the actions in the region? Please.
Yes, I can try to start answering. We did not assess in this project these specific legislations, but we did have a couple of interesting learnings about, for example, the Employer Sanctions Directive. I'm sorry, I don't have any good examples of enforcing them, but for example, in Sweden, it works very poorly, and the research I mentioned by Märta Johansson has also covered that a little bit. But for example, in Finland, it was a year or two ago, the wage guarantee legislation was amended, and now also I think undocumented migrant workers have better possibilities to receive some wages from the wage guarantee system, but unfortunately it is a topic that hasn't been very much, at least in our findings. We didn't really see much good examples of it. So yeah, unfortunately, I'm not able to answer any better. I don't know if Tina has something to add, or Natalia.
Tina, do you want to say something on this one? No, okay. I just as a general comment, I mean, we didn't really find like similar practices as in the Netherlands and Belgium on the use of the Employer Sanctions Directive. So I think this is an issue that still needs to be more discussed in the Nordic and the Baltic Sea region. But if I move to the next question, there's a question from Mark Heath on whether there is a business sector that is better at offering remediation. For example, is it easier to get remediation in agriculture than in construction? Please, Sara, Christopher, or Tina.
I would say, based on our findings, for example, in the construction sector, we did find several examples. So I would want to make the conclusion that it could be easier to get remediation there. And also there are, for example, in Sweden, there is a legislation regarding contractor liability in wage claims in the supply chain. So there is specific legislation on the construction sector that improves the possibilities to receive unpaid wages. And also, for example, in Finland, the Finnish construction sector social partners also have this kind of mechanism in their collective agreement that the buyer contractor is responsible for the subcontractors' workers' unpaid wages in certain cases. So based on those, I would say that, for example, in the construction sector, it is easier, especially if there are these national mechanisms or policies that regulate it.
Thank you, Sara. Tina?
Yeah, I would say I don't think you could sort of pick one over the other. Or I certainly wouldn't, because I see that there are many companies who do great work in those sectors. There will always be some laggards in both sectors, I think. But because they have been sectors that where migrant workers have been more exposed, and there have been more in media and so forth, I would say that there are good improvements. And in Norway, you have something called the joint and several liability provision in the General Application Act, which means that there is a joint responsibility in the supply chain between the different suppliers and subcontractors. And I also see that NGOs are now more starting to use this, and I think it's been maybe primarily used in construction, but it may be that this will expand, and I hope so, because it is a great way of keeping everyone liable to a greater extent, and it's easier than to go to someone other than the direct company in question to seek remediation and to use their leverage. Thanks.
Thanks, Tina. Christopher, would you like to comment?
Well, I share the same impression that there seems to be more work done in construction, even though ETI Sweden, we don't work with the construction sector, but we do work with the agriculture sector, but there are only a few cases and supply chains where that we know of in Sweden that concerns migrant workers. So but I wouldn't say that it's like one sector is better than the other, but seems to be more going on in the related to the construction sector. Yeah.
Thanks, Christopher. Okay, I'll move to the following question. There's a question by Susan Bannister saying many businesses rely on their whistleblowing processes as part of their remediation process, but most workers don't know what happens in the process. Is it confidential? Who has access to their information? How will they be kept informed of what's happening? So do we in the project have any good examples of businesses putting the worker at the forefront of the creation of their grievance mechanism? Please.
Unfortunately, no. In the findings we have done, in Norway, by law, companies who has more than 5 employees has to have a whistleblowing mechanism. And this system was often put in place before the whole UNGPs and the development in the business and human rights world happened. So I would say that whistleblowing alone is not the most effective forms of grievance mechanisms, and I think many approach this as a sort of legal risk system and a static system that is put in place, rather than seeing it as a continuous and also possible risk management tool that businesses can use in their larger human rights due diligence work to prevent human rights violations. So I think I mentioned it in my presentation as well that grievance mechanisms are much more effective if they are specifically designed to the needs of the specific companies rather than the whistleblowing. And the effectiveness criteria of the UNGPs mentions that workers should be informed all along in the process as an equal stakeholder. So I think, again, using the effectiveness criteria is a really valuable tool to assess your own grievance mechanisms.
In our, I can
sure,
also
please,
comment.
go ahead.
Yeah. In our dialogue, in our advisory services, there's often a misconception from companies that whistleblowing processes is a grievance mechanism according to the whistleblowing directive, and that this is just to have a telephone hotline that is suitable also for like migrant workers or their due diligence work, which is not always the case. So the remediation and the grievance mechanism channel need to be suitable for migrant workers. So there is really like a discrepancy between what the companies think that they have to do or what is like kind of like seeing it as a checklist exercise of just like putting up a hotline and then it's done. But this is really about making grievance mechanisms that are accessible also. But one example that I was thinking of is one of our members, Oxfam, is working not in the Baltic region, but in Southern Europe with some supermarkets on more worker-centric grievance mechanism. So that could be maybe interesting to look into if you're interested. And also the case that was mentioned by Electronics Watch, I think that's a really good example of a worker-centric process or a framework that is related to these topics. So those are some examples at least.
Can
Thanks,
I just
Christopher. Sure, absolutely.
Quickly add, there's also a report coming out of the University of Nottingham shortly that focuses on grievance mechanisms and access to remedy in the agriculture sector in the UK. And they've also done quite a lot of stakeholder engagement and work with businesses, and I think have good examples of worker-centric approach to grievance mechanisms.
Thank you, Tina. We have a few minutes left, so I'll just go to the last question. Thank you, Amy, again. Amy is asking, we refer to structural barriers that can create vulnerability and increase risks to exploitation. Do we see that the national labor migration law and policies also create vulnerability and increase risks, for instance, tied to visa regimes, no ability to change employers, and which ultimately impact on access to remedy and justice? Does any one of you want to add something on this?
I can just share a specific example from Norway. So the seasonal workers visa is for third country migrant workers outside of the EU. And the visa has not had a clause saying that the workers need to be accommodated by the employer, which also sometimes can come with risks. But the point here is that therefore, recruitment agencies have brought workers to Norway and they have facilitated the accommodation, but the Labour Inspectorate can only inspect accommodation when it's tied to the employer and not recruitment agents, meaning that there's been exploitation here that no one's been able to inspect, and therefore that has certainly exacerbated levels of exploitations to the point of trafficking for some workers.
Thank you, Tina. If I may just very quickly comment, because we're running out of time, on this question by Amy, I think definitely yes. I think there are a lot of practices and policies that actually enable and if almost also facilitate exploitation. I think, for instance, the berry industry question that we've been looking at is such an example. So I think there are examples in various sectors. But on this note, I would like to thank all of the participants and the speakers and our donors for this very interesting webinar. Just as a comment to Nina Mäki, who asked the question, we will answer by email because we don't unfortunately have time anymore. Please have a look at the report on our website. You can find also all our other reports and studies there. Thank you again for a very interesting and fruitful webinar. Thank you. The webinar is closed.
Thank you.
Thank you so much, everyone.